All right, we're going to go over the chapter questions for chapters 7, 8, and 9. Starting with chapter 7, question 1. What does the requirement that all parties have the legal and mental capacity to contract mean? The requirement that all parties have the legal and mental capacity to contract means that the parties must have the ability to understand that a contract is being made, have the ability to understand its general nature, and have the legal competence to contract. Question 2. When a contract is made between an adult and a minor, how enforceable is it against each or the parties? When a contract is made between an adult and a minor, the minor can avoid it or treat it as valid and enforce it against the adult. The adult cannot avoid the contract. Question 3. What types of contracts cannot be avoided by a minor? Contracts that cannot be avoided by a minor include contracts for necessaries, business contracts, and other specially enforced contracts such as student loan agreements. Question 4. With regard to contracts of minors, what are necessaries? Necessaries are items required for a minor to have a reasonable standard of living that are not provided by the minor's parents or guardian. Question 5. What is the obligation of a minor on disaffirming a contract? When disaffirming a contract, minors must return whatever they may have received under the contract, provided they still have possession of it. Question 6. How much of a voidable contract may a minor ratify? A minor cannot ratify part of a voidable contract and disaffirm another part. All or none of it must be ratified. Question 7. What is the safest way for an adult to be protected when contracting with minors? The safest way for an adult to be protected when contracting with minors is to have an adult join in the contract as a co-signer with the minor. Question 8. If Gordon, a minor, lies about his age to induce an adult to enter a contract, is he guilty of a tort? Can any resulting contract be enforced? Yes, if a minor misrepresents his or her age and the adult with whom he or she contracts relies on this misrepresentation to the adult's detriment, this is a tort. The law is not uniform as to whether minors are bound on contracts induced by misrepresenting their age. Question 9. What is the effect in most states of a person being formally adjudicated incompetent? In most states, contracts made by a person who has been formally adjudicated incompetent are void without regard to whether they are reasonable or for necessaries. Question 10. Can a person who has not been judicially declared insane and has only intervals of insanity or delusions make a binding contract? A person who has not been declared by a court to be insane and only has intervals of insanity or delusions can make a contract fully binding as if they were a normal person, as long as it was made during a sane or lucid interval. Chapter 8, Question 1. What is consideration? Consideration is whatever the promisor demands and receives as the price of a promise. It could be money, personal or real property, a service, or a promise regarding behavior. When does a promise constitute consideration? This is question 2. A promise constitutes consideration when the promise imposes an obligation on the person making it. Question 3. What is the relevance if grossly inadequate consideration is given by one party? If grossly inadequate consideration is given by one party, it is a relevant fact in proving fraud, undue influence, duress, or mistake. Question 4. When can partial payment of a past due debt constitute consideration to support the creditor's promise to cancel the balance of the debt? Partial payment of a past due debt constitutes consideration to support the creditor's promise to cancel the balance of the debt if the amount of the debt is in dispute, if there is composition of creditors, if the debt is evidenced by a writing and the writing is canceled and returned, if there is a gift of the balance, or if a secured note for a lesser amount is given and accepted in discharge of an unsecured note for a greater amount. Question 5. George agrees to remodel a kitchen for Harry for $30,000, but after beginning work, he asks Harry to pay $34,000. Can George enforce Harry's new promise to pay $34,000? Because George is already obligated to do the work for $30,000, the promise to pay an additional $4,000 is not binding unless George concurrently agrees to do something the original contract did not require as consideration for the extra $4,000. Question 6. If a boy promises his father that he will not own and operate an automobile until he is 18, in exchange for his father's promise to pay him $2,000, is there a valid contract? Yes. The promise of one party is consideration for the promise of the other. For the father, the value of the son's promise is $2,000. Question 7. When does forbearance not constitute valid consideration? Forbearance does not constitute valid consideration when one promise to forbear doing something one has no right to do, such as commit an unlawful act. Question 8. Under what theory will courts enforce a promise to pay a voluntary subscription? Courts will enforce a promise to pay a voluntary subscription under the theory that each subscriber's promise is supported by the promises of other subscribers. Question 9. Why is consideration unnecessary to support an obligation of record? Consideration is unnecessary to support an obligation of record on the basis that such an obligation is enforceable as a matter of public policy. Question 10. When will courts apply the doctrine of promissory estoppel? Courts will apply the doctrine of promissory estoppel when the promisor should reasonably expect to cause, and does cause, action by the promisee, and the promisee would be harmed substantially if the promise is not enforced. This is also referred to as detrimental reliance. Chapter 9, questions. Question 1. What does the determination of whether a mistake affects the validity of a contract normally depend on? Whether a mistake affects the validity of a contract normally depends on whether just one of the parties or both parties have made a mistake. Question 2. When will courts allow a unilateral mistake of fact to impair the enforceability of a contract? Courts will allow a unilateral mistake of fact to impair the enforceability of a contract if the non-mistaken party has caused the mistake or knew or should have known of the other party's mistake and the mistaken party exercised ordinary care. Question 3. When an oral contract is reduced to writing and through an error in keyboarding, the written form does not conform to the oral form, does the written form bind the parties? Explain. When an oral contract is reduced to writing and through an error in keyboarding, the written form does not conform to the oral form of the written form. It does not bind the parties. The contract is what the parties agreed to orally. Question 4. How can buyers protect themselves from a mistake as to the value or quality? Buyers can protect themselves from a mistake as to value or quality by requiring a warranty from the seller as to the quality or value of the articles they are buying. Question 5. Explain the difference between fraud in the inducement and fraud in the execution of a contract. Fraud in the inducement occurs when the party defrauded intended to make the contract but was told a false statement regarding the terms or obligations of the transaction between the parties. Fraud in the execution occurs when the defrauded party was tricked into signing a contract under circumstances in which the nature of the writing could not be understood. Question 6. When might silence constitute passive fraud? Silence might constitute passive fraud when one's relationship with another relies on trust and confidence. Question 7. When can a statement of opinion constitute fraud? A statement of opinion can constitute fraud if the speaker is an expert or has special knowledge not available to the other party and should realize the other party is relying on this expert opinion. Question 8. When does physical duress occur? Physical duress occurs when one party makes a threat of violence to another person, who then agrees to a contract to avoid injury. Question 9. When is a contract voidable because of undue influence? A contract is voidable because of undue influence if a party in a confidential or fiduciary relationship to another induces the execution of a contract against the other person's free will. Question 10. Why should the victims of acts that make contracts voidable, such as duress or undue influence, take steps to protect their rights? Victims of acts that make contracts voidable should take steps to protect their rights, because if they do nothing, their right to avoid the contract's provisions may be lost. Also, they might ratify the contracts by some act or word indicating an intention to be bound.